They said Trump made false and inflammatory statements about us wanting to eliminate Trump. It's grossly misleading, says Jay Bratt, falsely suggesting that we wanted to assassinate him. The court finds that Jack Smith's pro forma, she puts it in parentheses, conferral to be wholly lacking in substance and professional courtesy. She says it should go without saying that meaningful conferral is not a perfunctory exercise. If FBI ransacks Mar-a-Lago and Secret Service or Trump's private security starts popping off, we're being invaded by some freak show force here that's in plain clothes. We can't even identify who these people are. What happens if something pops off? There was a use of force policy that enabled them to use force. Jack Smith, embarrassed by Judge Cannon, she came out with a very short order because you don't need a long one when it's so thorough and brutal and simplistic. Jack Smith wanted Trump gagged, begged Judge Cannon in one of the most pathetic filings that we've seen here in some time for that gag, saying our agents are going to get killed. We're all going to die. We're all under attack because Trump is saying certain things. And turns out they didn't confer with the defense at all. They dropped this request late on a Friday, holiday weekend. Trump's defense attorneys came out and said you violated multiple rules and you should be sanctioned for this because your request is so ridiculous and egregious. Judge Cannon largely agreed with them, and we'll see what she says. Now, this is fun because Jack Smith has been on his heels in Florida for quite some time. Judge Cannon unsealing documents that are showing all the malfeasance and misconduct from him, and we've got evidentiary hearings coming up. It's going to be a doozy. But remember, this came from Jay Bratt, the Florida Oompa Loompa. Here is the 12-pager, just as a reminder on what this said. They were very concerned. They said Trump made false and inflammatory statements about us wanting to eliminate Trump. It's grossly misleading, says Jay Bratt, falsely suggesting that we wanted to assassinate him. And this is going to hurt our FBI agents. The FBI took extraordinary care, and we did a bunch of planning, and we tried to restrict the force, but Trump said the FBI was authorized to shoot me. Well, because I guess if something would have escalated, they would have had that authorization if it was reasonably necessary to protect the life of the FBI agent or whatever the protocol says. So they say this is causing threats and harassment, and Your Honor, you need to gag Trump. And so they go through, this is Jay Bratt's big whiny email. Please gag Trump, we're all gonna die, and you have the right to do that. The court should exercise its authority to impose a condition because we don't want agents to be smeared, and he doesn't have the right to say these things. And so these agents conducted this search in an appropriate and professional manner. And Trump saying that he tried to kill him, they tried to have him killed, has endangered these law enforcement officers. And so he must be restricted. All right. So that's Jay Bratt. Now, Trump's team responded to this. So Jay Bratt filed this, and then there were some emails, or before the filing landed in court, there were some emails back and forth. So Bratt says, hey, your client is now saying some naughty words, Todd Blanche, defense attorney, and we're going to file a motion to restrict him. And so that's what these emails sounded like. We've got the exhibits that came out from Trump's defense attorney. So here's how it went down. You see here, Jay Bratt, the Florida Oompa Loompa, counselor to special counsel, illegal Jack Smith, sent this letter. He sent it over to Todd and Stephen Weiss. He says, Todd, Emil, Beauvais, and Chris. He says, in light of former President Trump's recent false statements about the inclusion of the FBI standard use of force policy in the operations plan in the search of Mar-a-Lago, and the danger such statements create for the agents who participated in the search, we will be filing a motion to modify conditions of release to prohibit him from making statements that pose a significant, an imminent, and a foreseeable danger to law enforcement agents participating in the investigation and the prosecution of this case. We assume you will oppose this motion and will want an opportunity to discuss and respond. Can you please confirm? We plan to file the motion later this evening. If you would like to discuss further, please let us know. Thank you, Jay. This came out, this email, Friday night before a long holiday weekend. And so Todd Blanche, you can see Friday, May 24th at 5:30 to Todd, Emil Beauvais, and to Chris. 5:30 at night, end of the week. So Todd Blanche, he responds at 5:40 Friday, 10-minute email. He goes, all right, let's get to this. You know, it's easier if you just deal with it. As soon as it comes in, all right, that's fine. Let's go, Jay. He says, Jay, yeah, we very much object to a 5:30 p.m. email on Memorial Day weekend asking our position on a very serious motion that has First Amendment implications and addresses the conditions of release of President Trump. Yeah, a 5:30 p.m. email on a Friday before Memorial Day is not meeting and conferring in any sense of the word at all, and certainly not as we have been ordered to do by local rule and Judge Cannon. As you know, the names of law enforcement officers associated with this investigation and associated with the prosecution of this case have been redacted from all public filings, so no one even knows who they are. So there cannot be a real imminent danger, as you're well aware, if no one knows their names. So Trump can say whatever he wants about them, but no one knows who they are. So there is no danger. The imminent danger standard is not going to be met. And so why are you even here? Moreover, Jay, you have not articulated to us which statements you believe have been made by President Trump that would rise to the level of a, quote, significant, imminent, and foreseeable danger to law enforcement agents participated in the investigation and the prosecution of this case. And as such, because you can't even articulate what that standard is, there is no basis to claim that you have done anything meaningful to meet and confer with us prior to filing a motion seeking the relief you articulate below. We are available, sure. We can actually meet and confer on Monday afternoon, which is the holiday. This will give us time to meet with our client and to discuss whatever position we believe to be appropriate. Thank you. Todd, totally reasonable. And he responds very quickly, 5:40. So Jay Bratt, he says at 6:43. Jay Bratt, he's a prosecutor, takes a little longer. So he's like, thought I was done for the night. 5:40. So Jay Bratt takes an hour and 3 minutes, and he squiggles out this paragraph. He says, Todd, the former president issued a statement on True Social on May 21st, 2024, containing the false accusations, and a second one on May 23rd. He included similar statements in a mass fundraising email on May 21st and in a second one on May 23rd. In light of your client's opposition in other cases to any limitation on what he can say based on the same First Amendment implications you mentioned below, we do not believe that further conferral would be productive. In other words, we've already seen you in other cases objecting to all the other gag orders, so we don't suspect that you're going to agree to this one. And so we don't think there's any reasonable chance or any productivity in your concurrence in our motion. Like, you're not going to agree with us in any way. You're not going to concur. Now, even were the situation otherwise, waiting until Monday afternoon to speak is unreasonable. As recently as this afternoon, Mr. Trump reposted a statement on True Social again. Jay Bratt is sitting there like, he keeps talking bad about us. Prosecutors hate when you talk bad about them, which is why we like to do that here, because they hate it. They think they work so hard. They got a badge. They're like, I'm a prosecutor. Like, I'm out doing justice. Like, oh, what are you doing? DUIs? Yeah. As recently as this afternoon, Mr. Trump reposted a statement on True Social again, making the false accusation and adding new ones. And so further conferral will be a fruitless exercise and does nothing to mitigate the danger your client is creating. So we will include in our motion that you do not believe we provided you an opportunity for meaningful conferral. So we'll just tell the judge and the judge will deal with that. So Todd says, oh, okay. Well, he responds, 6:55. Man, Todd is lickety split. Look at this. So Todd Blanche, he's trying to keep it under 10 minutes, but this one is 12 minutes. So he responds in 12 minutes. He drops this whole thing. So it takes Jay Bratt a full hour for this stupid paragraph. Well, I'll tell the judge, if you don't think, I'm not waiting. Someone's going to die if we don't answer this right now. We're going to file it anyways, right? Okay. So then Todd returns and he says 10 minutes later, 12 minutes later, he says, Jay, what? He says, you still have not informed us of what statements you claim pose a significant, imminent, and foreseeable danger. You have now informed us when the statements have been made and in what forum, but you are seeking to modify bail conditions, and in doing so, you have not in any way, shape, or form informed us of what statements he has made that you believe warrant this relief. So our position is not that you have not provided an opportunity for meaningful conferral. Our position is that you have completely failed to meet and confer. So as you know, the local rule requires you to do more than just inform us that something was said and that based on that statement and prior positions of our client, you assume we would oppose. So if you're going to file your little motion there, Jay, why don't you include this following position from us in your motion? At 5:30 p.m. on Friday evening, you can include this, Jay. The special counsel informed us that they were seeking to modify President Trump's bail conditions on as yet unidentified statements purportedly made by President Trump on True Social and in fundraising emails. They indicated that they were filing the motion tonight without informing us of the statements that they claim give rise to the relief sought, and without allowing defense counsel to respond as required under the local rules. Defense counsel has had no opportunity to confer with the special counsel's office, nor have we had an opportunity to confer with our client about the requested relief. Defense counsel indicated it's available over a holiday weekend on Monday, a holiday. The special counsel refused this good faith effort. This is a blatant violation of the Florida local rules and the prior orders of this court, Judge Cannon. And so we oppose this motion being filed in this format and ask that it be summarily dismissed because of a lack of effort to meaningfully meet and confer. Now, in the past, you have refused to put our stated position in your motion. We asked that you include this position in full. Guess what happened? Jay Bratt didn't do that. So Jay Bratt responds, he says, Todd, 7:45. So he takes about another hour. Todd, in light of the coverage, your client's truths and campaign emails making false claims about the FBI's standard use of force protocols, I find it hard to believe, Todd, that you are unable to discern the statements contained within those communications that create the danger we previously referenced. He's like, what, can you read, Todd? Do you even know how to read? Nevertheless, I'm attaching those communications to this email with the relevant language highlighted in yellow. So he printed out the true social. We decline to put verbatim in our pleading the statement of your position that you set below. The portion of the motion describing the conferral process is not a platform for you to make arguments, Todd. We will fairly summarize your position as we've done so in the past. Jay sends that one in. And so Todd responds, 7:45 to 7:53. This is so irritating when you do this. And defense attorneys can be great at this. The other person we saw do this was Ashley Merchant, just brutal. As soon as you send it, ooh, fire it right back out. It's called war. This is a good concept in life in general. We're always ready. War. No matter what we're always ready. Send it, boom, fire it right back. 9 minutes. He says, Jay, yeah, do what you will. This is a blatant violation of the local rules and Judge Cannon's previous admonishments of the special counsel's conduct in complying with the rules of the court. This has not stopped the special counsel before, and it appears it will not stop you tonight. We will respond in due course. It is troubling that a representative of the United States has no issues violating the rules of the court when it so suits, but here we are. I am curious when the drafting of this motion started and why the special counsel waited until 5:30 p.m. to comply with the rules of the court by requiring a meaningful meet and confer. How come? At this point, it's no longer surprising that the rules are not followed, even by representatives of the United States in theory sworn to uphold those very rules. Jay Bratt is freaking fuming right now. I assume by your response below that you will choose how you will represent our position as opposed to representing our position as articulated by us below. I am actually speechless at this point. I don't have a response beyond what I have written below, Todd. And so he says, Jay, you didn't even inform the court that you wrote us at 5:30 p.m. tonight regarding a meet and confer. So then the motion gets filed. All right. So Jay then just files it because he's just fuming. He probably files it another hour later. Then it gets filed. So 7:53 happens. Jay, do whatever you want. Jay turns around, files the motion. It drops on the Friday night. We hear about it. Then he responds right after it's filed. He reads it and he says at 8:09, Jay, he's thinking, I just read your motion. You didn't even inform the court that you wrote us at 5:30 tonight about a meet and confer. Do you want to correct that before we respond or no? Please let us know. So you didn't even tell the judge. And now there's a response from David. David must be another prosecutor. Jay Bratt's probably agitated right now, having a meltdown. So they say, Todd, dear Todd, as we attempted to explain before, our reasoned expectation was that like many other motions that have been filed in this case by both sides, there was no likelihood of further conferral resulting in an agreement or even narrowing the issues before the court. So they just decided we don't have to meet with you, even though the judge said you do. Your side has solicited our position shortly before filing other motions where the expectation was correctly the same. So in other words, you've done this before. Also, as we are also tried to explain earlier, our judgment was that the situation your client has created necessitated a prompt request for relief that could not wait the weekend to file. We understand your position and represented to the court that you do not believe the government has engaged in an adequate conferral here. I write here tonight to hopefully explain our reasons for doing so. Signed, David. And so Todd says, okay, well, David, thanks for all of that little note. 9:33 p.m. Man, he's keeping it under 10 minutes, man. This is good, Todd. Less than 10 minutes. 9:33 same night. David, there are rules. You guys violated them. I appreciate the attempted explanation, but it does not in any way pacify us. I am beyond amazed that the government would misrepresent facts to the court about what happened. You didn't even bother to inform the court that you reached out to us for a meet and confer at 5:30 p.m. on a Friday night of Memorial Day weekend before the filing of the motion at 8 p.m. You gave us like 2 hours to talk about our release conditions and our free speech with our client. I'm confused as to why you think we could not meaningfully meet and confer about a path forward short of a motion. You did not even bother to inform us of the post and fundraising emails that gave you concern until 20 minutes before you filed the motion. We would have been more than willing to discuss with you your concerns prior to filing the motions, but you had an agenda and you stuck to that agenda. It is not surprising, but still disappointing. The court may agree with you that the path you chose was was the right one, I do not know. But please do not try to justify a blatant violation of the rules, and beyond the local rules, Judge Cannon admonition to all of us last summer. You all made a decision tonight to file this motion without complying with these local rules and Judge Cannon, and that is your decision. We will respond accordingly. Signed, Todd Blanche. And so those are the exhibits in the filing. Here is what the defense said. All right, Jay, and dear Judge Cannon, this is Trump's motion to strike and to request sanctions based on what they submitted. They say, well, Jack Smith is here. They're seeking to impose an unconstitutional gag on Trump based on some vague and unsupported assertions about some law enforcement personnel, FBI agents, whose names have been redacted from public filings. And for the reasons set forth below, well, Jack Smith's office is violating the rules. And so the court should strike the motion entirely, make civil contempt findings as to all government attorneys who even participated in the decision to file this, and impose sanctions on them after holding evidentiary hearings about the decision to willfully disregard your prior procedures. Not happy. Saying following a string of procedural abuses, Judge Cannon, and misrepresentations, Jack Smith, over the course of many months, this court has admonished them. The court admonished Jack's office to just calm down. Just calm down. You guys are like lunatics. Far from it, Jack Smith's office contacted defense counsel about filing a motion at 5:30 p.m. on a Friday evening before Memorial Day, as Trump and his counsel prepared to deliver the defense summation in People versus Trump on the morning of Tuesday, May 28th. That's the New York case. We responded immediately, on average less than 10 minutes. Todd Blanche, got a stopwatch. But Jack's office declined our request. We said we'd meet him on Monday on a holiday. All we wanted to do was meet with Trump. But Jack's office did not specifically identify any of the evidence they cited until about 15 minutes before they filed the motion. And as with prior filings by Jack's office, the motion fails to identify any direct evidence of the purported safety risks. Just Trump is dangerous. Jack's office did not even dare seek emergency relief in the filing, as no relief is warranted. Thus, there was no basis for rushing to file it. They didn't mark it emergency. This is bad faith behavior. It's plain and simple. Saying, Your Honor, the misconduct by Jack's office is even more worthy of sanctions in light of the context here. The motion is extraordinary. It's unprecedented, and it's unconstitutional censorship. The motion unjustly targets President Trump's campaign speech while he's the leading candidate. It also treads new on extremely problematic ground because they're asking for a prior restraint that's different from the other gag orders. Here, they seek as a condition and condition Trump's liberty on his conformance with Jack Smith and what Jack Smith thinks about the case. And they want the probation office to mediate the disputes between these two people, saying for the purpose of this application, that all matters because there is no reasonable dispute here. Pursuant to the local rules, they did not meet and confer with us. They're supposed to, they didn't. Instead, they persisted with a troubling pattern of pursuing media coverage rather than justice. They wanted to file the motion so they could get out to the media that they're trying to gag Trump for being illegal. Now, such an approach by prosecutors sworn to uphold the law should have no place in this courtroom. And so we need consequences. Here's what happened. At 5:30 p.m., Jay Bratt said, we're going to file this motion later. We already read through those emails. 10 minutes later, we notified him. We said, what? 5:30 on a Friday, we object. There's no basis for your suggestion that anyone's facing an imminent danger. And so how about we meet you on Monday? Now, they responded 1 hour later because they're slowpokes. He made a vague reference, Jay Bratt. He says, oh, I don't know, just something happened. He filed, it's danger. Then at 6:55, Trump's defense responded. He said, you have completely failed to meet and confer. You haven't identified any of these statements, and the local rules require you to do it. And finally, concerned that they plan to file the motion, we asked them to include the statement that we read previously, saying you guys are total losers. Now, in response, they demeaned counsel. They said, I thought you were smarter than that. What, you can't read Todd? You can't read his Truth Social post? And they mocked the assertion that Jack's office should specifically identify the statements. Why should we find it? In Jay Bratt's view, it was incumbent on the defense to discern the social media posts and to discern the campaign emails that they're relying on. But nevertheless, he then attached them to the email. He also informed the defense that he would not include our position, but he says, we'll just summarize it for you. Then 15 minutes later, they filed the motion. The office failed to note that they first contacted the defense when they sent this into Cannon, that they declined our invitation to meet on Memorial Day. Now, despite attaching certain alleged statements to the 745 email, Bratt did not even attempt to confer regarding Exhibit 4 to the motion, which we learned of for the first first time after the motion was filed. They say they've already disregarded this, Judge, a long time ago. Last year in July, the court denied a motion because they didn't confer. On November 3rd, the court warned Jack Smith about a notice filing, says don't do that. In addition to that, they've repeatedly made meritless arguments. They seek sealing of documents. They seek ex parte proceedings, meaning they just try to bypass everybody and go directly to Judge Cannon. Now, this court warned the office about making sweeping and unsupported claims previously. And last month, the court already found that the office had failed to offer a governing legal framework, only making conclusory and unsubstantiated assertions about whatever Jack wants. Now, the Jack office is not campaigning for any office, as far as we're aware, but his prosecutors have pandered to the media and public filings. Trump's defense says this has included gratuitous and prejudicial language, where Bratt recently admitted that this was admitted despite the rules. Now, the office has also included lengthy explications of purported facts in public filings. They keep writing stupid things like this in their little high school motions. They say, quote, to set the record straight, and before turning to those arguments from the defense. Garland behaved in a similar fashion when he was making extrajudicial statements in January. He said a speedy trial was necessary. Now, these tactics include a public filing that's threatening you, Judge. They threatened you with frivolous mandamus litigation. They say, we're going to take you up on appeal, Judge Cannon, unless you give us what we want. And also other lawless interlocutory appeals concerning hypothetical jury instructions. The import of this behavior was not lost on Your Honor, Judge. We know you know they did this, and the court appropriately described all this garbage from them as unprecedented and unjust. On May 19th, the court also deemed it necessary to express concern over how they're treating sealed material. The court's concerns included the office's argument that unsealing was appropriate. The court noted that the court was disappointed with Jack's opportunities presented. Now, finally, just last week, in response to another troubling show of tone and demeanor at a hearing, when David Harbach was out there clapping, remember, he was like, Judge, you can't do that to me. And the judge said, just calm down, relax, weirdo. So they say, look, the rules say, local rule 88.9, you have to meet and confer. It's an integral part of our adversarial system. Now, they don't talk about sanctions in the rule, but you should still sanction the crap out of them. Jack Smith's office violated the local rules. The court has warned his office repeatedly. There is a pattern of unprofessional conduct in this case. In order to deter such behavior as the case proceeds, the court should strike the motion, make civil contempt findings as to all government attorneys who even participated in this. Go and get them all. I want to know who even edited this, who ran the spell check on this document, and impose sanctions following an evidentiary hearing to determine what their motives were and their purpose was in filing what they did. It's just media. They just are mad that Trump has a megaphone and they don't, so they just respond in their filings. It's unlawful. Under no circumstances can an email exchange initiated at 5:30 p.m. on a Friday evening constitute any type of meaningful conferral. For President Trump, the fact that Jack's office initiated this on a holiday weekend is less important than the fact that the office, well aware of the proceedings in Trump's trial, took the steps to try to do this when closing arguments were set to begin in May 28th. In other words, they know they're about to be in court on another case. They file this to try to rush them and gain an advantage. Now, despite that schedule, defense counsel offered to consult with President Trump over the weekend and discussed the motion on Monday, Memorial Day, but the office barely acknowledged that request. So the failure to meaningfully confer is even more troubling in light of the fact that the parties were in court together on Wednesday. Now, the office cites in a motion on May 21st, a May 21st social media post. So Trump posted on Tuesday. They showed up in court on Wednesday, could have addressed it on Wednesday. They didn't. They waited till Friday, knowing that the defense team had summations the following week. If the office truly believed that Trump's constitutionally protected speech really posed the type of imminent threat that they claim in their motion, they should have discussed it with us on Wednesday, not Friday. And this timing is not justified by exigent circumstances either. They've completely failed to substantiate their position here as why this is imminent. As we've noted throughout, Trump and the defense team have great respect for law enforcement agents who do their job with integrity. We will not stand in the way of credible assertions about potential safety risks, but on the other hand, we will not acquiesce to unsupported histrionics from biased and reckless prosecutors who've shown no respect for the First Amendment at all. The court is well aware of the prosecutors' failures in this regard because an extraordinary amount of attention has been devoted to the arguments by Jack's office regarding the need for sealing to protect witness safety. He's been arguing this for a long time. Defense counsel has conferred extensively about redactions, and that process resulted resulted in a bunch of redactions. We invited Jack's office to propose other redactions, but at no time did any of them seek to redact the use of force information. They could have redacted this a long time ago if they were so concerned about this. Idiots. To our knowledge, the unsealing of these materials did not result in credible safety risks to anyone, obviously. Now, Jack's office presented no actual evidence of safety risks either. They just wanted to respond in the media because Trump was obliterating them with the assassination plot revelation. Especially after the office's complete failure to satisfy any of these safety claims, this is pretty troubling. There was no basis for them to suggest some sort of emerging risk like we're all going to die. They filed at 8 p.m. on a Friday. No one who signed the motion, these so-called government prosecutors, could reasonably have expected the court or its staff to act on the application before business hours resume on Tuesday. Nor could Smith himself. Rather, the office plainly filed the motion in pursuit of some other objective, the media, which has not yet been identified, but should be appropriate to sanction them for that. So, for example, the motion was not even styled as an emergency motion. The rules say this is how you file an emergency motion. So they could not have expected the court to even act on the motion over the weekend. So we could have met on Monday. There was no urgent decision coming. So there's no indication that the motion discussed the application with probation, as would be required if you're going to do a patently unconstitutional modification of this. The Bail Reform Act does not contemplate a modification absent a hearing anyways. And not even Smith and his team dared suggest that the court convene the parties on Memorial Day to address it. So the local rules and the basic professional norms from Jack contemplate Trump would be afforded a reasonable amount of time to respond. Now, despite their strained and inaccurate claims about urgency, they did not even seek an expedited briefing schedule on this. There were no exigent safety concerns referenced at all. All of this to say, the timing in the motion is bad faith. And finally, while we're not even addressing the merits of this motion about what Trump said or whatever, a few preliminary points are in order. One of the senior officials who authorized the raid at Mar-a-Lago said he frankly doesn't give a damn about the optics. That is them on record. I don't give a damn about the optics. I don't care if we have to shoot half the facility. But now, Jack's office seems to care about those optics very much. Yeah. The motion quotes liberally from D.C. Court's review of the unconstitutional gag order from Chutkin, but fails to address one of the key points. Working in the criminal justice sphere requires some thick skin. Unless you're an FBI agent, then you're petrified. That Smith is, once again, attacking Trump's campaign speech is conclusively established by the fact that the office attached a campaign email. It's a campaign email. Once disfavored, but now in vogue for prosecutors driven by political animus against Trump, gag orders reflect an extremely serious threat to our constitutional traditions, especially when they're applied to political candidates. The motion goes one step further, however, in seeking to condition Trump's liberty on his compliance with what these government prosecutors want him to believe. Thought police regarding what constitutes fair argument in 2024 should not be dictated by these three prosecutors. The motion is unprecedented. Its abuses are manifest. If and when there is an appropriate time, we will forcefully address this on the merits. But for now, the point here, they should not have filed this. The decision by Jax to do so, and do it when it did, cannot be explained in a manner that's consistent with confidence in these proceedings. And so this court should have an evidentiary hearing. We should dig into this and determine where this bias and animus came from, because we're going to add that to our selective and vindictive prosecution filing. For that reason, make these determinations, make civil contempt findings to all government attorneys because they did not meaningfully confer, and we want to know why they willfully disregarded your required procedures, Judge Cannon. Good stuff from Emile Beauvais, Todd Blanche, Christopher Keese. Powerful motion because they chronicle all of the other times that Jack Smith has just flagrantly violated the judge's orders. And so Cannon came out and gave them the old backhand. In fact, here is what Cannon said in response. Jack Smith gets slapped. She says, all right away. This is a paperless order denying without prejudice Jack's motion. There will be no gag. Why? Lack of meaningful conferral. She says, upon review of the motion, Trump's procedural opposition, and the email correspondence that we just read, the court finds that Jack Smith's pro forma, she puts it in parentheses, conferral to be wholly lacking in substance and professional courtesy. She says, it should go without saying that meaningful conferral is not a perfunctory exercise. She's not happy about this. Sufficient time needs to be afforded to permit reasonable evaluation explanation of the requested relief by opposing counsel and to allow for adequate follow-up discussion as necessary about the specific factual and legal basis underlying the motion. This is so even when a party, as you guys did, Jay and Jack, assumes the opposing party will oppose the motion, and it applies with additional force when the relief sought, which here was a gag order, at issue for the first time in this proceeding, is being raised in a procedurally distinct manner, and it implicates, the First Amendment, the Constitution. Now, because the filing of Jack's motion did not adhere to these basic requirements, it is due to be denied without prejudice. Any future non-emergency motions, Jack, that are brought in this case, whether on the topic of release conditions or anything else, shall not be filed absent meaningful, timely, and professional conferral. Now watch this. Moreover, all certificates of conference going forward shall, 1, appear in a separate section at the end of the motion. So she says, I want you to fill out this form and attach it to the back, showing me you did it. And I don't want it embedded in an editorialized footnote, Jack, with your stupid comments. Just fill out the form and attach it. And you must specify in objective terms, not like your opinion, bro. Cannon says, I want to know the exact timing, the method, and the substance of the conferral conducted. So Jay Bratt and Jack Smith just got grounded, right? Your mom came in, says, you're grounded. Next time you do this, you're going to show me you did it, and you're going to keep a chore log on the refrigerator. And when you come home, this is what you're doing. And we're going to put your initials there and right here, and I'm going to check it off when you do it. I want to know when you did your homework, what you worked on, and how long you worked on it. We're going to get those grades up, young man. Okay. Same to you, Jack. Start a spreadsheet. Failure to comply will result in problems. And I also want, if requested by Trump's counsel, I want no more than 200 words, so shut your yapping mouth, from the opposing side on the subject of the conferral. Again, in objective terms. I don't want your opinion. Failure to comply with this, Jack and Jay, with these requirements may result in sanctions. They're in trouble. They're grounded. In light of this order, the court determines to deny without prejudice Trump's motion, so Trump doesn't get those sanctions and the total backhand. But Judge Cannon just said, Jack Smith, you have to keep a spreadsheet log, and I want to know when you met and what you talked about. Bring your doctor's note next time into this courtroom. So absolutely beautiful and exactly right. Now, of course, people like Andrew Weissmann, let's see how long we can listen to this one for.
In order to be able to curb what is happening with Trump, is there a fear that there's going to be a First Amendment issue that's going to be raised by Trump's defense?
Well, I can't believe I'm about to say this, but I disagree with Brad. I think this is something that is absolutely outrageous. I think this is the kind of thing that is going to be, when Judge Cannon denies Jack Smith's application, when it gets refiled, I think this will be taken up to the 11th Circuit. This is something that the government obviously cares deeply about. Indeed, the Attorney General of the United States talked about how this was a dangerous and false misrepresentation by the former president. Endangering law enforcement is the kind of thing that is the reason that you go into government to try and prevent and to make sure that you are upholding the people's safety, including those in law enforcement.
All right, those poor FBI agents. Trump said that there was a kill order. I'm not actually like go and kill someone, but if FBI ransacks Mar-a-Lago and Secret Service or Trump's private security starts popping off, we're being invaded by some freak show force here that's in plain clothes. We can't even identify who these people are. What happens if something pops off? There was a use of force policy that enabled them to use force in the document. Now they say it's copy and pasted from every other stupid document and search warrant raid, which you say, okay, well, do other people die in search warrants and raids? Yeah, they do. It's pretty regular. So is it outside the ordinary to say, if you copy and pasted the same thing that resulted in dead people over there, why is it not possible that there could be dead people here? It's the same policy. You just admitted that. So Garland and the rest of them now want to engage in the court of public opinion. So they file these motions and they respond that way, but it's not ethical. And it is being done because they're losing this case. He says that this is all going to be appealed and Judge Cannon's going to get backhanded. I don't think that's the case at all. In fact, it feels like Jack Smith is on trial in this case. We just had a whole litany of all his unethical misconduct, and Cannon has scheduled multiple evidentiary hearings and is going to be digging into into these issues about selective and vindictive prosecution and many other issues. So we'll be here, of course, continuing to cover this. So thanks for subscribing wherever it is you're watching this. We got great content on this topic and many more, including in our next segment. You got to see what the Supreme Court has done, because SCOTUS has totally snubbed and given the old slap to the Democrats who demanded to meet with SCOTUS. SCOTUS says, get the heck out of here. So that's coming up in this next segment. Be sure to check that out.